In this week's episode of Off the Clock, we continue our conversation about government investigations at your workplace.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Do search warrants ever entitle law enforcement officers to ask questions of people?
So they don't entitle the law enforcement to do that. They can do that anyway during the search warrant, and it's just a voluntary interaction that, of course, does not feel voluntary. They can ask you that, and as long as you're not under arrest, they don't even have to give you Miranda warnings. It's just asking you questions, the same as if they showed up at your door.
So now we're back to that first category.
That's exactly right.
They're not asking questions pursuant to a legal process or a document that entitles them to.
That's right.
And requires you to answer.
That's right.
They're just chit-chatting.
And they can send you a subpoena for testimony later, and that's when you do have to show up and you do have to answer within certain boundaries. You still have the right not to incriminate yourself and certain other boundaries as well that you can talk with your attorney about.
Got it. But if they're there with the search warrant, you mentioned one of the reasons legal counsel can add value is we can just inform people of their rights, that they don't have to talk to the officers executing the search warrant. That's not what the search warrant covers.
That's correct.
In a sense.
That's correct.
Right. Okay. Excellent. Anything else on search warrants people should know if someone arrives at their door with the search warrant?
Again, stay calm. Don't volunteer any more information than you absolutely have to, and try and catalog for yourself what was seized during the execution of the search warrant, just because that's something that is going to fade from your memory very quickly, and especially when you have a lot of other stresses in those moments. It's just helpful to have that.
So let's turn now to subpoenas. You mentioned it in passing earlier. That's another type of legal process.
That's right.
Right? What is a subpoena?
So a subpoena is a document that enables somebody to compel you to produce documents or other evidentiary material or testimony. And so they're going to show up and serve that subpoena at your company, and you're going to have to, if it's directed at the company, then you're going to have to comply with it, assuming it's not overbroad and there's no basis to contest it legally.
So unlike a search warrant that usually doesn't require an immediate action, right? Someone is walking into your company with a subpoena in hand and then wanting to go back and search the file cabinet?
So they don't get to go in and search then.
Okay.
They give you the document and they give you the subpoena and you produce the documents. It's, when you say immediate, sometimes it's immediate, and oftentimes that happens because people let the subpoena sit on their desk for a few weeks and don't give it to their attorney, which we would recommend against doing. But there is a deadline to them, but there's a delay where you're producing the documents rather than somebody else coming in and taking them from your organization.
So it's usually the delivery of a subpoena, but not law enforcement in the reception area wanting to talk to someone or search someone in the moment. Right?
They may combine it with a request to talk with someone, but it's not. They're not going to start rummaging through your file cabinets using a subpoena. That does not give them the authority to do that.
And it doesn't give them the authority to speak with someone immediately either, correct? They may ask to.
That's correct.
Where we started. But that would not be with, someone could say no.
I'd
rather not speak to you.
That's right. In that moment. Now, keep in mind, if it's a subpoena for testimony, if it's a grand jury subpoena, for instance, you have to comply with that and show up and testify.
Right.
And you're definitely going to want to talk to counsel as quickly as you can if that happens.
So let's just get this out of the way right away. When your company gets a subpoena, in my opinion, you should always check with legal counsel, unless your company is in the business of getting and responding to subpoenas, like sometimes with medical records and things like that, right? It's an everyday occurrence. But if that is not your organization, anytime you get a subpoena, it's a good idea to run it by counsel, in my opinion.
Yes, I 100% agree. Do it quickly.
Because there's always a deadline in a subpoena. There's always a date, either a deadline or a date for testimony or whatever it is. And sometimes, these forms are not easy to read or decipher, but there is always a date certain, and sometimes the turnaround is pretty quick.
Yes.
And those subpoenas, I will interject. This is a question I get from clients who receive subpoenas. One of the first questions I get is, do I have to respond? And the answer is yes. It doesn't mean you have to do, I want to hear your take on this to see if you agree with me. In my opinion, the answer is always yes. It doesn't mean you have to do what the subpoena tells you to do, but you have to do something. You have to do what the subpoena says, or you have to object to it through court process, which would require usually a lawyer,
Sure.
right, filing a motion saying why you're not going to do what the subpoena orders you to do. But a subpoena, even though it is signed by a lawyer, this is what is so confusing to people. It's just signed by a lawyer, just someone like me or you, right?
That's right. For the
Or
most
Sarah.
part, there's some that require judicial authorization, but they're limited.
Interesting. And civil subpoenas, right? They're just signed by the lawyers.
That's right.
But they have the force of a court order, right? Is that your understanding as well? So that if you disregard it, ignore it, throw it in the trash, right? You could be held in contempt, theoretically, contempt of court.
Yeah, you don't want to disregard it for a number of reasons.
So we agree on that.
But
That's
I mean,
good.
not least of which is if it is overbroad and you give it to your attorney can typically negotiate limitations on that. And if
Right.
the other side is being unreasonable, can file a motion to quash or something that has your interests at heart and in limiting whatever the subpoena is requesting you produce. So it's really important to give it to your attorney quickly because
Yeah.
it's not just the act of producing whatever documents you ultimately have to produce, which itself takes time because you want to make sure that you're producing the right documents, you know what you produce, you're not producing privileged information. There are a lot of steps in there when complying with the subpoena, but it's also the front end where you may have an overbroad subpoena and you want to start negotiating with the other side so that you produce a limited subset of information, and that way you limit your costs, you limit what information is going out the door. So getting that to your attorney quickly, early in the process, it's just very important.
Yeah, I agree as someone that sometimes gets them late. It's often easy to get extensions, I should mention, unless there's a trial or a hearing happening the next week. But if it's in the general course of a discovery case, which is oftentimes in employment law and HR, right? That's usually what it is. Usually getting an extension is not a problem. But it's always worth passing by a lawyer to see if we can limit it in scope, making sure there's no confidential information. In addition to attorney-client privilege documents that we don't want to turn over by accident.
That's right.
Sometimes for organizations covered by HIPAA, right, that could add some elements. You can have a HIPAA compliant subpoena, but we'd want to make sure that's true. If there's confidential or proprietary business information that is within the scope of how the subpoena was written, we're going to want to either narrow that scope or we're going to want to get some sort of protective order, right, so that it's only filed under attorney's eyes only or other ways, right, to protect your proprietary business information. So there's lots of things we can do,
That's right.
but we do need time.
And it's so context dependent too. It depends on the business. It depends on the type of
Yeah.
information requested, and that's why it's good to give it to somebody who's used to issue spotting in those areas, like you just mentioned.
Yeah, and so that is something that more than just the receptionist has to be aware of. Because oftentimes subpoenas are mailed, sometimes even, I mean, this might not necessarily be proper service under the court rules, but this is what happens in real life, right?
That's right.
An attorney in a case has one person's name and contact method. I won't say serve, but send a subpoena or deliver a subpoena in that way, and then that person just responds or starts responding. In my opinion, again, unless you're kind of in the business of responding to subpoenas, which some are for various reasons, there should be one person who is the point person at the company who should be handling all those. And if you don't have an in-house counsel, which a lot of our clients don't, it's time to reach out either to the head of HR, the COO, the CEO, risk manager, someone like that, right?
Yeah, I agree with that 100%.
That whoever it is in your business that has a direct relationship with outside counsel would be a great person to be the point person.
But it's not just that they have that relationship with outside counsel. They're used to dealing with subpoenas, and so they get used to saying, "Oh, there's a reason I need to do this quickly," and
Yeah.
here's the document, pass it along to counsel, and then it just helps with efficiency. It helps with the organization, and it helps outside counsel deal with it.
Anything else you want folks to know about when they are faced with some sort of government? I don't even know how broadly to say it. Law enforcement, but I don't mean just the police, right? There are agencies that have enforcement tools, like the Department of Labor, for instance. We don't think of them as law enforcement, but sometimes they show up at people's doors, right, and start asking questions, et cetera. Anything else you want people to know in those situations about how to respond or not to?
The bottom line in all those situations, and I think the theme for today is just don't make things worse. It's already not a good day. Don't make it a worse day.
That's true in so many contexts. Can I use that?
Yes.
Every type of question that comes up from.
Can you tell I'm not an optimist?
So, Andrew, you were with law enforcement, right? Doing investigations from the law enforcement side.
That's right.
And so at Miller Johnson, we've started this new investigation group to draw on experiences like yours. Can you tell us a little bit about that?
Sure. So I'm really excited about this because Miller Johnson's always done investigations work, and they've done investigations work in a lot of different spaces, healthcare, employment, some on the white collar criminal defense side. And we've decided to build out from that experience an internal investigations and compliance practice group where we use that experience. We make sure that people who are doing internal investigations are talking with each other, adopting best practices, and we're adding to that my experience with the Department of Justice, Fadwa Hamoud's experience with the State Attorney General's office. And so now we just cover so many different types of investigations as part of one internal investigations practice group. I'm just really excited about how this is going to go.
I am also very excited. As people know from watching this podcast, I love investigations. We've done podcasts in the past about how to conduct an investigation kind of yourself, right? There's an allegation made. What do you do to find out what really happened? Your expertise in FADWAs and so many others in our new group is how do you handle an investigation from the outside, right? When someone else wants to investigate you.
That's right. And it sometimes they're not mutually exclusive, right? Where the government comes knocking, you need to find out what happened as well before you have a chance to respond or prepare your defense or whatever else you may want to do in response to the government's investigation. So in that sense, they work in tandem with each other.
Okay, so we like to end our episodes with takeaways. So it sounds like the takeaways are have a plan or a policy in place, just like you would for any sort of not uncommon but serious matter like workplace violence, fire, tornado, etc. Right? Have a point person. Make sure everyone knows they're not to respond themselves, right, to subpoenas, to law enforcement, etc. This is the person that handles all of that for the company. And then secondly, don't make it worse.
That's right. If we had high-level bottom line points, those would be them.
Awesome. Thank you so much for joining us today.
Thanks for having me. This is great.